Good afternoon, everyone, and thank you for attending our next event in the OG Energy Education Series, an overview of land, title, and leasing issues in Ohio. As we look to bring you new and exciting formats, similar today, we have three different presenters, being myself out of Columbus, Josh Peterson, a senior attorney out of our Houston office, and Margaret Chavez, an attorney out of our Houston office as well. So we'll be covering today an ownership of land in Ohio, sample title issues, and the Dormant Mineral Act. With that said, I'd like to kick it over to Margaret now.
Thank you, Josh. I will be starting us off today with an overview of ownership of land in Ohio. We're going to begin with a brief discussion on separate property before moving into three types of co-tenancy, those being tenancy in common, right of survivorship, and tenancy by the entirety. We'll briefly touch on Dower Interests before moving on to a discussion about life estates and the open mind doctrine. And I'll briefly touch on race notice statute in Ohio before turning things over to Josh Peterson. Beginning with separate property, you're going to be able to find all things separate property in the Ohio Revised Code, Chapter 3105. This covers all things divorce, annulment, dissolution of marriage, because that is typically when courts are determining and examining whether property is separate or marital. So below we have a list of different types of separate property. I want to highlight just a couple of them and provide some examples. The first being any property obtained by either spouse before the marriage. So an example of this would be if X owned a property in Carroll County prior to entering into marriage. X then marries Y, and shortly after marrying, X and Y then purchase a property, let's say one county over in Harrison County. Well, the property that X owned in Carroll County would be separate property, X's separate property, because he owned that prior to marriage. However, the property in Harrison County would be marital property because X and Y purchased that after marriage. Moving a little further along to separate inheritances by either spouse. This is something we see most commonly, and an example of separate inheritance would be if X's father died, X would inherit his father's property, let's say in Stark County, and that property would be X's separate property, even if X is married to Y at the time of the inheritance. Another one that I want to expand upon a little further is gifts that can be proven by clear and convincing evidence to be made solely to one spouse. Clear and convincing is where things get a little bit tricky, and this is always going to be a heavily fact-specific inquiry conducted by courts. There's a semi-recent case from 2021 called Herman versus Herman, and I'm going to briefly go over the facts of this because I think it helps to show what can be used as evidence here to prove that a gift was made solely to one spouse. So in Herman versus Herman, this case is out of the 3rd Appellate District in Putnam County, and it took place in 2021. Essentially, the issue is whether property gifted from the wife's parents, we'll call this the lake property, was separate or marital property. The reason why there was confusion as to the ownership status is because the property was gifted to the wife, the lake property was gifted to her while she was married to her husband. Additionally, the title of the lake property was in both the wife and husband's name. So when the wife and husband went to divorce and divide the marital assets, the wife claimed the lake property as separate property and the husband claimed it as marital property. So in trying to determine the status of the property, the court heard testimony from the wife's parents who stated that it was their intent to give the property to the daughter as an early inheritance. As noted on the slides, separate inheritances are separate property, so that would lean towards this being separate property. Additionally, the court looked at other gifts of property that the parents made to the wife's siblings. All of the siblings were married at the time of these gifts. However, the title was to the siblings only, which pointed towards the parents' intent to convey property only to their children, not their children's spouses. Finally, the wife's father testified that the property had been in the family for many generations, and it was his hope that the wife would pass the property on to her children, and so on and so forth, keeping that property in the family. In considering all these factors here, the court determined that the trial court was correct in determining that the lake property was in fact the wife's separate property, notwithstanding the fact that title was held in both the wife and her husband's name. I will briefly mention that separate property can become commingled with marital property. Again, that is a very fact-specific inquiry, and we don't have time to get into that now, but feel free to email myself or Josh Abrams or Josh Peterson if you're interested in learning more about that. We're now going to touch on different types of co-tenancy, the first being tenancy in common. Now, a tenancy in common, the operative words must convey or devise an interest in real property to two or more people. Essentially, what we're looking for here are the words to A and B, or it could be to A, B, and C. As long as there are two or more, we're going to have a tenancy in common. It's important to note that the tenants in common do not have to hold equal shares of the property. However, if that is the intent, it must be expressly made clear. So if you wanted, you could say to X 1/3 and to Y 2/3. That would be perfectly acceptable. You could say to A 1/3, to B 1/6, to C 1/6, to D 1/3. Again, all perfectly acceptable. Now, if a deed is silent and does not expressly convey the shares in a stated portion, it will be presumed to have equal shares. So if all we had was two A and B, we would assume that A has a 50% interest and B has a 50% interest. I will note that that presumption is rebuttable. Two ways you would rebut the presumption of equal shares would be to show that there was an unequal contribution to the purchase of the property, or a mutual intent by the parties to hold the property in unequal shares. So just remember that the equal shares presumption is in fact rebuttable. Moving on to our next form of co-tenancy, joint tenancy with right of survivorship. Before we dive into the words of conveyance, I want to note up front that grantees do not need to be married in order to have a joint tenancy with right of survivorship. Oftentimes, we will see that the grantees are married, but that's not a requirement. We commonly see mother-daughter, father-son, or siblings listed as joint tenants with right of survivorship. The words of conveyance here must clearly, again, create an intention to create a right of survivorship. The conveyance must state the grantees and reference that the survivor is in fact entitled to the remainder. And below we have the most common form of the language to create the joint tenancy with right of survivorship. Now, the implications here are that each tenant has an undivided interest in the entire property. So each tenant may possess the entire property. The key thing to note is at death, the joint tenant share is extinguished. So once the joint tenant receives a certified certificate of death, they will then attach that to a certificate of transfer or to an affidavit, and you will then file that in the county in which the real property is located. And after that is filed, then the joint survivor or the joint tenant has the entirety of the estate. I know I already mentioned this, but I can't stress it enough that you do not need to be married to have a joint tenancy with right of survivorship. But because we commonly see that, we wanted to briefly touch on divorce. Now, we've included the entirety of the provision from the Ohio Revised Code. I'm not going to bore you to death by reading it verbatim, but if you would like to refer to these slides later, you'll have the entirety of the provision there. Now, the key takeaway when it comes to divorce and joint tenancy is that if the entire parcel is held by two joint tenants who are married to one another and they later get divorced, the title immediately upon divorce ceases to be a survivorship tenancy. Instead, it becomes a tenancy in common, which we previously covered. Now, the default would be that both spouses hold 50% interest. Of course, there's always an exception. The exception here would be if the judgment of divorce, annulment, or dissolution of marriage expressly stated that the spouses were to hold unequal shares, and the judgment then outlines which proportion each spouse would own. Now, we can have more than two people as joint tenants with rights of survivorship. So, what happens if we have, let's say, three tenants, one who is married to the other and one who is unmarried? So, A is unmarried, B is married to C, C is married to B. What happens if B and C divorce? Nothing impacts the joint tenancy with right of survivorship there, even the termination of their marriage. They will all three remain joint tenants with right of survivorship, unless, of course, the judgment says otherwise. Moving on now to estate by the entireties. This is opposite of joint tenancy with right of survivorship in terms of the marriage requirement. To have a tenancy by the entireties, the grantees must be married to one another. I also want to highlight that tenancy by the entireties, we're only looking at the period from 1972 to 1985. Tenancy by the entireties could only be created within that window. Now, there are three requirements to create tenancy by the entirety. The first being the language estate by the entireties must be written either in the title or the body of the deed. Second, there must be language of survivorship in the text of the deed. You will note here that that language is the exact same as the language required for a joint tenancy with right of survivorship. And third, the most important part, the grantees must be legally married at the time of the deed is executed. I'm going to briefly go over the facts of the case listed here, the Shelton case, to provide context for what happens when all three requirements are not met. So in 1974, Jesse Cleverdon executed a deed, an estate by the entireties with survivorship deed, and he transferred his property in Parkman Township to James Shelton and Mary Elizabeth Shelton. Now, at the time of the conveyance of the property, Mary Elizabeth Shelton was married to Ralph Roland, not James Shelton. Her legal name at the time of the transfer was Mary Elizabeth Roland. Now, Mary Elizabeth Roland and Ralph Roland legally separated 5 years after this creation of the tenancy by the entirety. Mary lived with James on the property from the time of transfer to the time of her death, and later both Mary and James died intestate. The issue arose when the executor of James' estate was trying to distribute his estate, and we needed to determine whether James had held this as a tenancy by the entirety. Now, the court noted that because Mary was married to Mr. Roland, not Mr. Shelton at the time, a tenancy by the entirety was not created. However, the inquiry didn't end there. We needed to determine how the two held the property, given the tenancy by the entirety failed. And Ohio courts had been split on the issue. One line had held that failure of a tenancy by the entirety causes the grantees to take title as co-tenants. Another line held that the failure of the creation of the tenancy by the entireties caused the grantees to take as joint tenants with right of survivorships. A fact-specific inquiry would follow, and the court here decided that because the express language to Mary and James for their joint lives, remainder of the survivor of them was present, that was enough to create a joint tenancy with right of survivorship. So although the tenancy by the entirety failed, James and Mary held the property as survivorship tenants. Again, before we move on, I just want to highlight that tenancy by the entireties that were created between 1972 to 1985 remain valid, but from 1985 onward, you could not create a tenancy by the entirety. Touch on Dower. I know that most people tuning into this webinar are familiar with the concept. The main thing that I want to note here is Dower is one of the main reasons why it is important to include the grantor's marital status when executing deeds. Without stating the grantor's marital status, there's no way to know if someone is out there holding a dower interest that's not been released and relinquished. And of course, that would be a cloud on title. Most commonly, you're going to find the dower release towards the end of the instrument, shortly before the signatures. Recently, though, I've been seeing this towards the top of the deeds when it will say X, a married woman, and Y, her husband, signing to release his dower rights as grantors. That's just putting you on notice, but you'll typically find the dower releases towards the end of the instrument. Moving on to our next slide, life estates and remaindermen. This is something, again, that most participants are familiar with, so I just want to touch briefly on the fact that both life tenants and remaindermen cannot commit waste. The life tenant only has the right during their life to occupy and use the property, but they do not have the right to unilaterally operate for oil and gas or grant an oil and gas lease. Similarly, the remainderman has an ownership in the physical property, but does not have the right to possess or use the property until the life estate is terminated. So, looking at some of the implications of this, it's crucial that you lease to both the life tenant and the remainderman, whether you do that in one instrument or two. As long as you have leased to both, you should be okay there and ensuring that waste is not committed. Where do things get hairy here? It's typically with the division of proceeds. So the general rule is listed below. It's that the life tenant receives the income from the property, the remainderman receives the corpus. Now, typically, the royalties and lease bonuses are going to be considered part of the corpus, and the delay rentals, if there are any at all, are going to be considered part of the income. The best practice here is going to be obtaining a written agreement or a payment directive from all parties regarding the payments. And all payments, that includes the bonuses, the royalties due under the lease. We want to make sure that's all outlined clearly in the payment directive, just to ensure that everyone's being paid their proper shares. Of course, there's always going to be an exception, and the exception here is the open mind doctrine. So this rule was established in Foster v. Foster. Under Foster v. Foster, we were looking at a situation where a father created a life estate. In 1971, Mr. Foster conveyed real property to his children and reserved a life estate for himself. Now, the 1971 conveyance from Mr. Foster to his children made no reference to mineral rights. It did not reference any existing oil and gas leases and any existing oil and gas wells. Notwithstanding this, Mr. Foster had executed 3 oil and gas leases several years prior to this conveyance in 1969. These 3 leases were all still valid and not expired when he created the life estate. Shortly after creating the life estate in 1973, Mr. Foster created 2 oil and gas leases. It's important to note that he executed these 2 new leases on his own, and there was no release or lease executed by the remaindermen. After the 2 oil and gas leases were created in 1973, the lessee then learned that Mr. Foster only had a life estate. So this is where the issue arose, and the court determined here that Mr. Foster had the right to benefit from the 3 leases executed in 1969 because those were executed prior to the creation of the life estate. However, the 2 leases that he created in 1973, 2 years after the 1971 creation of the life estate, those would be considered invalid because, again, he did not have the authority to execute those leases on his own without a corresponding lease from his remaindermen, his sons. So the purpose of Foster is to clearly reject the proposition that the open mind doctrine should be extended to new oil and gas wells or leases opened solely on the authority of the life tenant. Looking at the implication here, it's again laid out in Foster that it is the lease that opens the mine. Thus, the open mine doctrine can apply even if a well wasn't producing at the time that the life tenant took possession, and it can apply to new wells during the life estate. Now, in the interest of time, I'm not going to go into the example that's provided below. It's slightly different than the facts of Foster, but again, you have access to these slides on the right hand of your screen. and I encourage you to refer back to this example later. My last slide today is going to be on Ohio's race notice statute. Again, something most of us are familiar with here. The key thing to take away is that a bona fide purchaser is a subsequent purchaser who is without notice of an earlier conflicting interest. Essentially, the first one to record their interest is the one who will have the clear title. I do want to note that there is an exception for mortgages, which Josh Peterson will be briefly touching on next as he goes over different types of encumbrances. Thank you.
Thanks, Margaret. I'm going to be starting with conveyances and encumbrances. This will include unreleased mortgages, judgment liens, transfer on death designations, ownership by a trust, and land installment contracts. Unreleased mortgages. So how do mortgages affect an oil and gas lease? And the critical question is, do operators need to go out and get subordination agreements? Thankfully, in Ohio, subordination agreements are usually not necessary. Under the Ohio Code, where you have a lease that's recorded after a mortgage, as long as that lease is not in default, then that lease is going to have priority over other liens of the property. And even if there is a foreclosure of the mortgage, it's not going to have any impact on the lease. And so what happens is if you do come across a foreclosure, then the purchaser of that foreclosed property, they basically just become the new lessor, and any payments due under the lease will just be made to them. Sometimes when you come across mortgages, you'll see a nuisance waste provision. And that's really just the lender trying to further protect their collateral. And it does require consent from the lender. So if you come across something like that, it is necessary to get consent from the mortgagee or the lender. What about old mortgages? We do have a statute of limitations that helps us clear old mortgages. It applies to 21 years after the date of the mortgage or 21 years after the maturity date, whichever is later. After that time has passed, that's not going to put anybody on notice that there is some kind of unpaid debt. So just by way of quick example, if you have a mortgage from, let's say, the year 1998, and there's no stated maturity date, if you come across that, since more than 21 years have passed, you can consider that mortgage as being paid, and it's no longer going to be a cloud on your title. Judgment liens. Private judgment liens are going to remain in effect usually for 5 years. After that, they kind of go into a dormant status, and they're not going to be considered a lien against the judgment debtors. Certificates of judgments that are in favor of the state, those are going to last longer. Those won't go dormant until 15 years. And then if you happen to come across a judgment in favor of the United States, those last the longest, being 20 years. And all of these liens that I've mentioned, they can all be renewed. So it's important to make sure that you don't come across any kind of continuation of the lien that has been timely filed of record. And then lastly, as far as after acquired title, it's usually not going to apply to property that's subsequently acquired by the debtor. Transfer on death designations. Under the Ohio Code, a designation such as this, it's going to have no effect on the present ownership of the property. And the person who's designated beneficiary has no interest in the property until that original owner dies. For this reason, these types of designations, they're easily revoked or changed at any time. You don't have to have the consent of the beneficiary. And if you happen to be looking at title before December 2009, you'll probably notice these were done by transfer on death deed. Operates much the same way, easily revoked, easily changed, including by the grantor conveying a subsequent deed even to themselves. So just by way of a quick example, let's say in 2018, a landowner designates his daughter as transfer on death beneficiary. Maybe a few years later, that landowner decides to sell his land to a neighbor. Well, that conveyance is going to automatically revoke the prior designation to his daughter a few years back. And as I've come across these a lot, it's important to note that if the surface has been severed from the oil and gas estate, and somebody executes a designation affidavit, there's a good chance it may only be applicable to the surface estate, or it may only be applicable to the oil and gas estate. Implications here, Margaret covered life estates and Remaindermen. Typically, you need to get both to execute a lease. Here, with these beneficiary designations, you only need to get a lease from the owner, not the death beneficiary, because again, that death beneficiary has no interest in the property until the owner passes away. Divorce, and what impact does that have on a death designation? Ohio follows what you might call a divorce revokes type of rule. So if you designate your spouse as a transfer on death beneficiary, and then there's a subsequent divorce, that's going to automatically terminate the designation, and that spouse is going to be deemed to have predeceased the owner. So again, it's basically a divorce revokes type of rule. Property acquired by a trust. This is probably a recap for a lot of us, but your basic trust scenario will involve a settlor, sometimes called a trustor, and they're the ones who establish the trust. They'll convey the trust property or the corpus to the trust, and that is for the benefit of the beneficiaries who may receive income or principal. It just depends on the terms of the trust. And then the trustees are the ones who manage and distribute those funds. Whenever we come across a trust, we have to have certain documents, and those are necessary to make sure that A, the trust lawfully exists, and B, that the trustee is operating within its powers. Because every once in a while, you may come across a trust that may prohibit the sale of oil and gas. And so that's why it's necessary to have documents establishing the trust, documents designating the trustees, in powers, identifying those powers. And so normally you'll find all those in one trust document, but again, sometimes it may be piecemealed, especially if there's been, amendments to the trust. Implications, again, really need to get the documents that establish the trust, or there's an alternative procedure under the Ohio Code where you can obtain and record a memorandum of the trust, and that basically will set forth kind of the most important parts of the trust. Occasionally, you'll come across a blind and undisclosed trust, and what that is, it's a conveyance to, for example, John Doe, the trustee, or John Doe agent, and there's no other indication in the document or the materials that tells you the name of the trust or whether the grantee's powers are limited in any way. When you come across that, that's not going to put you on notice or any kind of inquiry notice that a trust or agency exists. So you can, again, absent other information, you can kind of just treat those as conveyances to John Doe individually. Land installment contracts. I included the definition here, which I'm not going to read, but essentially this is a sale of a property where the seller is financing the deal themselves. So the vendor, who is the seller, they're going to retain legal title, and that protects their collateral, but it's subject to the vendee's or the buyer's equitable interest in the property. And then once the purchase price is paid in full, usually over a number of years, then that's the point you'll see a recorded instrument where the vendor is actually conveying legal title to the vendee or the buyer. New lease implications. If the land installment contract provides that the vendor or the seller is to retain the oil and gas rights, then who should execute a lease? Here it's going to be the vendor only, and that's because the vendor has legal title to the property and the vendee does not have an equitable interest in the oil and gas estate. So vendor owned. More times than not, you're going to see a land installment contract that says nothing about, oil and gas being reserved. When you come across that, the question becomes who needs to execute the lease. Those situations are different. And so best practice is really going to require that you get both to execute a lease. And even further, it's always helpful to have a payment directive. So you're covered as potential disputes between the parties as to who's to receive what payments. Oil and gas leases. Here, I'm going to cover exemptions from licensure for certain independent landmen, determining if a lease is held by production, failure to pay royalties, and then I'll finish with a discussion of the definition of minerals that we see in reservation or conveyance language. Certain exemptions. In 2019, the Ohio legislature, they passed a statute that exempted oil and gas professionals the real estate licensing requirement. And that was definitely a good thing because there had been a prior ruling by the Ohio Supreme Court that really left these individuals susceptible to penalties, basically because the court said that they would have been, operating without a license when negotiating leases. But again, don't have to worry about that. There's a full exemption as of 2019. The exemption is going to apply to oil and gas professionals. That's defined really broadly, but that's going to include anybody who's involved in the negotiation of oil and gas leases, pipelines, and other types of agreements. However, to receive the exemption, you do have to follow some rules under the statute. First, you need to register annually and pay a fee. Second, you do have to provide evidence that you're a member of a professional organization that's developed ethical standards as far as conducting these transactions. AAPL would be a good example. And then third, you are required to provide certain disclosure forms to those you're transacting with. Implications. Keep in mind, this exemption for independent landmen, that's not going to apply to fee simple transactions involving oil and gas rights. If you're involved in that, then the landman is still going to need to be a licensed real estate broker. And for those who are working in-house, if you're negotiating a lease or purchasing minerals on behalf of your employer, that's has its own separate exemption, so no need to worry there. Production and paying quantities. And this kind of lends to the discussion of trying to determine if the lease is still held by production in its secondary term, also known as the addendum clause. The Ohio courts have interpreted PPQ as being a quantity of oil that's sufficient to yield a profit, even small, over operating expenses. And so the operator does not have to recover drilling costs or equipment costs. It doesn't matter that the whole undertaking may have resulted in loss. Again, they're really looking at whether there's even a tiny profit over those operating expenses. Further, the burden's going to be on the lessor or the landowner to show that the lessee has forfeited the lease by failing to pay in PPQ. So kind of a tough burden for landowners sometimes. We had the Brown versus Artex case out of the 5th District a few years back, and that told us that PPQ requires first-hand evidence and not just what's on the ODNR's website as far as trying to prove PPQ. And so you really have to exercise caution when relying on these production records from the Ohio Department of Natural Resources website. Operators are required to report production under the statute. If it's a horizontal well, they're required to report every quarter. If it's a vertical well, they're required to report every year. And I do want to point out, whenever you're looking at these records online, it can be a little tricky. And I just want to note that there's definitely a difference between zero production being reported for a certain year, that being the numeric zero, versus just nothing being reported at all. And keep in mind that just because an operator may be in violation of the statute as far as failing to report, that's not necessarily firsthand evidence that there wasn't production. So a lot of times, just take it with a grain of salt. And a lot of times you're going to need to conduct an investigation to really determine whether there is actual production from the well. Also, something I came across that I thought was interesting, on the ODNR's website, they basically include a disclaimer saying this exact thing. They say that the information it's compiled based on what operators send to it, and they especially make no guarantee as to accuracy of any of the information. And they also say that the information may not reflect all of the production that has actually occurred. Again, there's kind of a warning from the ODNR itself. Determining if the lease is held by production. So here we're talking about temporary cessation of production. This is when there may be a short-term or temporary lapse in production. Usually that's not going to be enough to terminate the lease as long as the operator is exercising reasonable diligence and they're acting in good faith in attempting to restore production. It's not going to terminate the lease. And it's important to note in Ohio, there hasn't been a court that's deemed a lease forfeited for less than 2 years. So again, they're looking at a short period of time, but 2 years is kind of at least a good guidepost to start with. You will find that sometimes a lease will take this a step farther and they'll include a no automatic forfeiture clause that gives the operator even more protection, because if there is an alleged violation of the lease, then that requires the lessor to send the alleged breach in writing to the operator, and then the operator gets a period of time, usually 60 days or so, in which to cure. So again, that's just another protection that operators sometimes include. Does failure to pay royalties terminate the lease? The short answer is typically no. Failure to pay royalties is not going to be grounds to forfeit the lease unless, and that's the big caveat, unless there's an express provision that gives them power. And Ohio's following basically the majority of other jurisdictions in that regard. Implications: most leases are not going to contain that express forfeiture clause. So whenever there's a failure to pay royalties, usually, and again, it depends on the lease, the remedy is going to be damages and not just complete forfeiture of the lease. Definition of minerals. The question here is, does a severance or reservation of coal and other minerals include oil and gas? And the short answer is, it depends. We've run into this issue a lot at our firm lately, and it usually involves older instruments, especially ones from the turn of the century. Typically, they'll reserve coal in other minerals or some kind of variation of that. We did get some helpful guidance out of the 7th District a few years ago, and it basically tells us that we can start with the presumption that the phrase other minerals may include oil and gas rights, as long as the language can reasonably be seen to include those rights, and there's no other language, of course, that excludes them. Now, if oil and gas was not commonly produced at the time the deed was written, then you lose that presumption. On the other hand, once production in Ohio is fairly commonplace, then when somebody references the word minerals, we can expect that they likely intended that to include oil and gas. Just some kind of case law here that's dealt with the issue. The very first case that delved into this was Deltler. In that case, they examined a deed from 1890, and it included a reservation of coal and other valuable minerals. The question was, does minerals include oil and gas? Well, the court here held that it did not. In its analysis, they noted that there were small amounts of oil being produced 10 to 20 miles from the property, but there was no evidence to suggest that the grantor had any knowledge of that. And the court also focused on the easement language, and there was really no easement language that could be seen as applicable to oil production. So basically, the court is saying, the parties at the time, they may have put the word minerals in there, but they weren't thinking that included oil and gas. Another case that dived into the same issue was Sheba. And here they looked at an even earlier deed. This one was from 1848, and they reserved all the mineral in coal. Same result. The court held that was insufficient to reserve oil and gas rights. And the court relied on the fact that, this deed was a lot earlier than the deed in Deltler. And again, there was a lack of evidence that there was oil and gas in the area. And for that reason, they didn't think that the parties contemplated the word mineral to include oil and gas. The last case I'll talk about is Corso v. Miser. This one is a little different spin. Here, they looked at a deed from 1949, and it accepted and reserved all coal and mineral underlying the property, but it had additional language. And that additional language was, it included the right to mine and remove the same as shown in deed to Henry Wick, wherein said coal is conveyed, reference to which is hereby made for a more complete statement. And so what made this case different is there was, in fact, a 1906 deed that had conveyed the coal to Henry Wick. And so the court, when it looked at this reservation, they said, the phrase all coal and mineral, it's limited because they include this reference to the Henry Wick deed and coal. So basically they said, due to that limiting phrase, it did not include oil and gas. Now, if we delete that language about as shown in deed to Henry Wick, et cetera, the court said that following prior decisions, then the phrase all coal and mineral would have included oil and gas. So just kind of the recap, when trying to determine whether minerals includes oil and gas, it's very much a fact-specific analysis. I would start with the presumption that minerals does include oil and gas, and then kind of work your way backwards. You're going to want to look at the precise reservation or conveyance language. That's critical. You're also going to want to focus on any easement language because almost all of these cases dive into an analysis of the easement language and whether it can be seen as being applicable to oil and gas operations. And then lastly, the age of the deed, it can be important because the older the instrument, again, the more likely there wasn't a lot of oil and gas development, and the more likely, the parties weren't thinking oil and gas when they used the word minerals. And with that, I will hand it over to Josh Abrams.
Excellent. Thank you, Josh. And to wrap up our presentation here today, I don't think any presentation on Ohio would be complete without at least a little discussion on either the Ohio Dormant Mineral Act or Marketable Title Act. And so for the interest of time, we're going to focus on the Dormant Mineral Act today. So in 1989, the Ohio legislature amended the Marketable Title Act when it enacted the Dormant Mineral Act effective March 22nd, 1989, to essentially provide a method for the termination of dormant mineral interests and the vesting of their title in the surface owners in the absence of certain occurrences within the preceding 20 years. So under the 89 DMA, the following is required. They can't be the subject of a title transaction as defined in section 531.47. So for example, a title transaction would be if the holder conveyed the severed mineral interest by a warranty, deed, quitclaim deed, or other instrument, or if the holder executed an oil and gas lease concerning the severed interest. There can be no actual pooled production of oil or gas, no storage of oil or gas, no drilling or mining permit, no claim to preserve filed of record, no separately listed tax parcel number created for the interest, and no ownership by state or governmental body. Now, due to the Ohio Supreme Court's decision in Corbin v. Chesapeake, prior to June 30th, 2006, if the surface owner filed an affidavit or other type of notice that the severed mineral interest had vested in the surface owner, this would actually be not sufficient because the Ohio Supreme Court specifically required a successful quiet title or declaratory judgment action by the surface owner. Then in 2006, the DMA was amended. And so the 2006 version of the DMA applies to all claims after June 30th, 2006. Under the 2006 DMA, the service owner must confirm no exemptions or savings events as outlined on the previous slide. The service owner must serve a notice of abandonment upon each holder of the dormant mineral interest or each holder successor or signs by certified mail return receipt requested at the last known address of each. And the notice must state that the surface owner intends to declare the dormant mineral interest abandoned and contains certain information as outlined in the statute. Lastly, the surface owner must record an affidavit of abandonment and a notice of failure of the file. So for proper notice, if the holder of the severed interest is known Proper notice can be achieved by sending notice of the surface owner's intent to declare the mineral interest abandoned via certified mail to each holder or each holder's successors or assignees at the last known address of each, with a return receipt requested. If the holder of the interest is unknown or cannot be located, the owner shall publish notice of the intent to declare the interest abandoned at least once in a newspaper of general circulation in each county in which the subject land is located. However, notice by publication is a last resort here. In fact, the notice requirement is actually the subject of most litigation concerning the DMA today. The issue essentially resolves around, what level of diligence or steps must the surface owner take to locate the holder or the holder's heirs and assigns to provide notice by certified mail prior to resorting to notice by publication. With that said, the Ohio Supreme Court has not adopted a bright line rule, so it is important to take a look at the cases reviewed to date, specifically looking at Gerrity v. Chervenak and Fonzi v. Brown. The facts in Gerrity are pretty straightforward, actually, but similar to most cases pertaining to notice under the 2006 DMA, they are necessary to go over to understand the Ohio Supreme Court's holding. So in 1961, T.D. Farwell conveyed property in Guernsey County to Robert Schaefer, but he reserved the mineral rights. Then in 1965, the severed interest was eventually conveyed from his estate to his daughter, Jane Richards, by a certificate of transfer, which listed her Cleveland address. Later, Richards moved to Florida and eventually passed away there in 1997. However, nothing was ever recorded in Ohio related to her death. In 2012, the Chervenaks, being the surface owners, searched the records of both Guernsey County and Cuyahoga County, which is where Cleveland's located. And they found the certificate of transfer with Richard's Cleveland address and sent their notice of abandonment by certified mail to this address, but it was returned vacant, unable to forward. So with unable to serve notice by certified mail, they ended up publishing their notice of the abandonment in the Daily Jeffersonian newspaper. Receiving no response, they recorded an affidavit of abandonment under the 2006 DMA, followed by a notice of failure to file. Gerrity, in this case being the sole heir of Richards, eventually discovered the abandonment and filed a declaratory judgment and quiet title action against Chervenak, arguing that because he had not received notice of the intention to abandon via certified mail, the DMA proceeding was ineffective. So the Ohio Supreme Court here looked at two different issues. The first being whether the 2006 DMA requires strict compliance such that a surface owner must first provide notice of abandonment by certified mail to each holder of a severed mineral interest before resorting to notice by publication. And two, the level of diligence required by a surface owner to identify all holders of a severed mineral interest in order to satisfy due process and utilize the publication provision of 531.56E. So ultimately here, the court ruled in favor of Chervenak, the surface owner, finding that the search under the 2006 DMA was reasonable. The court held that the surface owner attempting to comply with the 2006 DMA must exercise reasonable diligence to identify all holders of the severed mineral interest, but the inability to identify or locate all of the holders does not in itself preclude application of the 2006 DMA. So when a surface owner's reasonable search fails to reveal the names or addresses of holders of the severed interest, the surface owner may provide notice by publication. So here the surface owner searched the records of both Guernsey and Cuyahoga County, and the only item discovered was Richard's Cleveland address. So there was nothing of record indicating that, Richards had moved to Florida. So the surface owner was not aware that they should actually search there. So overall, Gerrity really is a big win for surface owners because they did not need to deploy an exhaustive, often fruitless search to identify all mineral interest owners prior to resorting to notice by publication. At the end of the day, the court essentially refused to adopt or oppose any bright line rule, so the standard will continue to be reasonableness. However, we look at, whether the surface owner's actions to identify all holders was readable from a hindsight approach, not but rather we'll look at whether it was reasonable based on what they knew at the time and what information was available to them. So you look at actually what they knew at that particular time when they did the research and looking back from present day to then. The last case I want to touch on is Fonzi v. Brown, because it is another major case analyzing the level of diligence required to locate the holder of the severed interest or the holder's heirs and assigns. In 1952, Elizabeth Fonzi conveyed property in Monroe County to Donald and Eva Jean Brown, but reserved a 1/2 royalty interest. The deed specified that Elizabeth and her husband, Harry II, actually resided in Washington County, Pennsylvania. They had 2 kids there, Harry III and Linda. Harry II and Elizabeth eventually divorced and each remarried, but neither had any more children. So Elizabeth ended up dying in 1989, while Harry II died in 1996. So in Harry's probate, actually, it was noted that his children were co-executors of his estate and his sole heirs. Fast forward to 2006, Brown, being the surface owner, acquired the property, and he hired an attorney in hopes of having the severed interest abandoned under the 2006 DMA. Despite having specific knowledge that Harry II and Elizabeth had lived in Washington County, Pennsylvania, Brown's attorney did not search the public records of that county, believing that he was only required to search the public records of Monroe County, where the property was located. So having found no heirs, Brown published a notice of intent to declare the severed interest abandoned, and that was actually published in the Monroe County Beacon, followed by an affidavit of abandonment under the 2006 DMA and a notice of failure to file. However, Harry III and Linda, being the heirs of the original owners, eventually discovered Brown's intent to abandon and argued that a search of the public records in Washington County, Pennsylvania, would have uncovered their father's probate proceedings and revealed that they were the heirs of the severed interest. So here, the court found that the surface owner's search of the public records in Monroe County and a brief internet search were reasonable because the surface owner knew that the holders of the severed interest resided in Washington County, Pennsylvania, and thus he should have searched the public records in that county. So it's no surprise, again, the court again did not set a bright line rule, but instead, applied the directive from Gerrity for reasonable diligence to be determined on a case-by-case basis. However, noting that generally a review of public records in the county where the severed interest is located will establish a baseline of reasonable diligence. The court also established that the surface owner always has the burden of proving compliance with the 2006 DMA diligence requirements. So here, again, the record indicated that, the holders had resided in Washington County, Pennsylvania, by virtue of that reference in the deed where the severed interest was created. And so the surface owner was basically put on notice that he should search there, which would have likely revealed that probate and identified the children as being the heirs and owners of that interest. So a little bit different than the Gerrity case where there was nothing indicating that you should search in Florida. Here, there was evidence indicating that you should search out of state. So at the end of the day, really diligent effort by the researcher is required before service by publication is appropriate. So if you have independent knowledge or other information that leads you to go out of county or out of state, reasonable diligence requires that lead to be followed. It's also important to note that notice issues continue to be litigated in Ohio, and that these cases are slowly clarifying what a reasonably diligent search entails. But still, as of present day, there is no right rule, which is why it's important to really take a close look at the facts of these cases. So with that said, that wraps up our presentation for today. I know we, put forth a lot of detail on this, so I hope this presentation can be, a reference point for you moving forward, as it will be sent out to all participants today. The program is accredited for 1 RL, 1 RPL, or CPL recertification credit, and 1 core CPLA credit. We've also applied for MCLE credit in Ohio and ADOA for a CDOA core credit. And so that CLE credit in Ohio is currently pending, hopefully be approved very, very soon here. And so we'll send up a follow-up email next week with further information on these credits. And as you can see here, here's the AAPL component code. So please feel free to download the APL affidavit from the handout section. And, because the affidavit will not be sent separately until our follow-up email has been sent. Please complete the post-event survey after the program has ended. And as Margaret previously mentioned as well, if you do have any questions, please feel free to reach out to myself, Margaret, or Josh. You can see our contact information here. We'd be happy to answer any questions that may come up. And again, I just want to thank everyone for, taking the time to attend today's presentation.